Hello everyone, myself MADHURI Paradesi, Associate Professor, Department of Law, Patnati Vidyalaya. Today we are going to talk about intellectual property rights. Here in this we can discuss what is WIPO, what is intellectual property rights in India, and what do you mean by that, what are the types you have, and so on. So let's see what is an intellectual property rights and how it has been started. This is nothing but an organization is called the World Intellectual Property Organization, which has been established by WIPO Convention in 1967. And this is a specialized agency on United Nations. It promotes protection of IP throughout the world, and its headquarters is in Geneva, Switzerland. Intellectual property rights, we can say that giving a particular protection to quantitative help to inventors and creators of the particular product. In India, we can say intellectual property rights are safely protected and controlled by well-established statutory and judicial framework. Apart from this, there are many attorneys and law firm of intellectual properties in India in various states also. What is intellectual property rights? This is nothing but one kind of a particular property arises from human intellect, and at the same time it is a product of human creation, and it is mostly divided into two types, that is the two distinct forms: literary and artistic works and industrial property. Literary and artistic works are nothing but books, paintings, music compositions, plays, movies, radio, TV programs, and other artistic works. So then how we can protect? We can protect by copyright. When we want to talk about industrial property describes physical matter, and it just gives you an idea, concept for commercial purposes. Now how we can protect? By patenting objects, by trademarks, industrial designs, trademarks, layout designs, and GI. There are certain kind of a particular major types of a particular IP. We can say that is the Patents Act 1970, which stands for Functional and Technical Inventions, and the Copyright Act, which stands on 1957 Act, purely on artistic works. When we want to talk about the Trademarks Act 1999, it just gives you protection in the way of a symbol, logo, word, smell, and design, so on. So patents, we can say it as 1970 Act, which has been amended several times, and it just extends to whole India. It will come into force on central government may publish by notification of official gazette. And a patent describes an invention for which an inventor claims an exclusive right when the particular invention is having new, that means novel, useful and non-obvious, and at the same time pertains to the patent. Then the particular remaining qualities exams became clear. So when we come to talk about the particular life and duration, a patent stands for 20 years from the date of filing for all types of inventions. Prior date and the first to file. The date of particular patent is the date of filing an application for the patent, and it just happened according to that. When we want to talk about a particular fee for the particular patenting, we can start the government fee, that is from 750 rupees for individuals and 3000 for the legal entities. And patent lapse if renewal fee is not been paid within the prescribed period, that we have to remember. And is a patent granted in one country can be enforced in other countries? No, not at all. The reason is this: there is nothing like a global patent or a world patent. Patent rights are essentially territorial in the nature. And at the same time, granting a patent in one country of the United Nations or any kind of nations can be taken in a different kind of a patent for the same inventions. And patent holders in India, if you want to talk, the list of the particular top 10 patent holders in India comprises only exclusively on pharmaceutical and biotech companies. So in India, there are 184 patents which has been given Council of Scientific and Indian Research, followed by Brand Banksy and so on. This we can give it as an example. Now the other part we can see is the trademarks. So it is covered under the particular Act of 1999. This Act comes into the particular way of September 15, 2003, and it replaced the Trade and Merchandise Market Act, that is 1958. And it also extends to whole India. It shall come into the force of central government may publish notifying official gazette and so on. So trademark we can say, and we can exemplarize, and we can define like a symbol, logo, word, sound, color, smell, design, and so on. So it can just gives you a different kind of productions, and TM contains, and it intends to use an application to file for the particular product. SM intends to use application file to the services. So register of the particular trademark, these two variations we have to look after. So for the registration procedure, you have to look after that. Application for the research, application for registration, examination of the trademarks, advertisement of trademarks, filing of an opposition, and then finally certificate will be issued to the particular person. And the duration, if you want to talk about, trademark is valid for the 10 years for the date of application which may renew for further periods of 10 years on payment of prescribed fee. Service marks rights are reserved according to this particular owner for 17 years and so on. So the government fees is 2,500 for each class of goods and services. So applicability of the particular trademark also stands a particular way of a trademark is a sign used in the connection with marketing of goods and the services, and this is also used in the particular way of goods means it may comes under appear not only in the goods themselves but for the creator or the container wrapper in which the particular products has been sold out. So some of the examples we can say is the Coca-Cola and KFC, Nike, like that. So we can just specifically give an idea of name, logo type, symbol, slogan, shape and color. And copyrights, if you want to talk, it came under 1957. It is just ground system of the particular copyright systems in India, and it has been amended several times, that is 1883 to 91 and so on. It is nothing but an exclusive right which grants the protection to the unique expression of your ideas. So the particular term original in the particular copyright law, it means a work originated from the author. There is no requirement for the novelty or the uniqueness as they are in patent law, that we have to observe. And the copyright law protects an expression of an idea, not the idea itself. What it covers the particular copyright? Literary works, films, dramatic, music, artistic and sound recording. So ideas, facts and at the same time recipes, works lacking originalities, names, titles and short pieces cannot be covered under the particular Copyright Act. Registration process, if you want to see, it is nothing but completing a simple application form along with an appropriate fee, not sending a copy of your work. Sorry, need to send a particular copy of your work. It appears with this particular same title, but if each work has been created independent. So duration, if you want to talk, or this lifetime, if it comes for the books and all, or this lifetime plus 50 years from the end of the calendar year in which the author dies. 50 years for films and the sound recordings, and 25 years of typographical arrangements in the public way. And copyright protections are always expires on December of the last calendar of the protection. And infringements, if you want to take, we can take actions when your right has been passing off, deceptive similarity or any kind of violation which has been taken, that comes under against imprisonments. Here, what constitute imprisonments? Any reproduction, use, distribution, performance of any kind of work with or without any kind of particular permission, without permission of a particular owner, that particular work cannot be taken. That constitutes imprisonment. An identical or substantial similar reproduction is also covered in this particular action. Imprisonment and the damages also will cover in that. And there are certain kind of remedies also. We can say that a suit can lie on a district or a high court. It may issue an injunction either in a prevent, imprison from any other kind, award damages to the patent owner, or will pay patent owner royalties for the further use. So you can also give under the particular way of iPhone patents and apply it in the suit. This is one kind of a case under the particular way of US intentional base where we can take Steve Jobs Apple CBO is also be taken. We think competition is very healthy, but competition should create their own original technology and technology, not stealing of a particular. This we have to remember. And the remedies, if you want to talk, a trademark imprisonments we have to talk about as district high courts, punishment extended to the 6 months to the 3 years, a permanent bans on engaging in commercial activities also. And successful civil enforcement also can be taken. 3 suits can find in the particular way of a particular ways, and the local commissioner also can take. Recently, damages or 50 lakhs awarded to this Adidas, that a famous shoes what we are using even in India also. Remedies, if you want to compare the particular copyright, a suit lie in the district courts, high courts under 63 of and Copyrights Act 1957, punishment with the particular imprisonments up to 3 years and as fine as the claims. So copyrights claims under these particular things that is other kind of garments what we have for the particular underlying artistic works, and these are some of the parts what we can cover under the particular overview of a particular IP rights. So finally I can say that you can just create yourself and whatever ideas or inventions you have rather than using their own others creations. So do not use competitive marks in such a way that it harms competitors, and it is also unfair way of using the particular products. So no comparison that they are likely to cause